We talked about the Kyle Rittenhouse case and the Julius Jones case in basically every single video in this month of November. Now, I don't want you guys to think that we didn't do that because those videos were important to make. Obviously, the Kyle Rittenhouse case took over the national landscape, and the Julius Jones case became near and dear to my heart and was very time sensitive. And there's still one more video on the governor's decision about Julius Jones coming soon. I'm just waiting for some more clarification on what the governor actually decided. Once I read through the written agreement, I will bring you a video about that explaining what went down and why it might not necessarily be the absolute worst news for that case. On top of that, I feel like I've said cross state lines 800 million times on this channel. Now, the crossing state lines thing is something that I was making fun of in the beginning of the Kyle Rittenhouse case, and I feel like it's taken on a life of its own, but we've brought it back home. I have a t-shirt design. It's about crossing state lines, so you guys can remember how ridiculous it is. If you want it, links in the description. You guys understand. But we're not going to talk about the Rittenhouse case. We're not going to talk about the Jones case. We're not going to go back to basics and shield ourselves from the virtual hellscape that is our world. We're going to talk about a case that we were following before, that's trial has been going on at the same time as the Rittenhouse case, which is, of course, the case of Ahmaud Arbery. But I did say shield and I did say virtual, so that's an ad transition. Now, a new surveillance bill proposed in Australia would allow the government to spy on and monitor all Australian internet activity. If this bill passes, the Australian government will be able to disrupt your computers, go onto your accounts, modify, post, and delete anything that they want, all in the name of security. It's the fact that nation states and corporations are cracking down on the free and open internet that has made VPNs so popular. And the VPN that I go to, the one that I trust, is Virtual Shield. Virtual Shield is a no-log VPN, meaning that none of your activity is being recorded by the company. It allows you to distribute your signal across other nations so that you can unlock content in other nations that maybe aren't available on Netflix America or similar. But most importantly, it secures your right to a free and open internet. Now, if you want to remain anonymous online, then you're in luck, because if you go to my custom URL, virtualshield.com/justice, you can get your first 30 days free, and because it's Black Friday, get 50% off your subscription for the rest of your life. You can't beat this deal, and again, with corporations and governments trying to figure out what you're doing, you better get on it quickly. virtualshield.com/justice. The Ahmaud Arbery trial, the trial of the McMichaels, is actually coming to a close, and it looks like, based on the way that the judge has delivered or proposed delivering jury instructions to the jury, that we are going to get a guilty verdict. Now, originally, based on the first video, when this information came out, I had said that I believed that the McMichaels were guilty of a felony murder. And the reason for that is because even though Arbery undeniably went for the gun, and there was clearly no premeditation in them trying to kill him, that just was not present, the fact is this case was always going to come down to whether or not the McMichaels had a legal authority to intercept Arbery on that street, not the fact that Arbery approached them, grabbed for the gun, may have actually discharged the weapon into himself first, and attacked the younger McMichael. We all know that happened. We all know that was on video. But remember, they're not being charged with murder because there was no premeditation. They're being charged with felony murder. I believe the felony was an aggravated assault, which could have occurred during the pursuit or could have occurred when they were threatening him with a weapon, what was perceived as threats with weapons. When the younger McMichael gets out the car with the shotgun at the ready, that's considered an aggravated assault, and thus Arbery dying during the commission of that assault led to all the parties involved being charged with felony murder, not murder. That was my original assessment. Now, we've had updates over time related to the case that lended credence to the fact that Arbery was in fact on that property because he was a burglar. First of all, we found out in the trial that the idea that nothing was missing from this property was just lefty media propaganda. There was stuff missing from the property. However, Arbery was not caught on video stealing it. There was stuff missing from a boat that was parked on the property on the time that Arbery entered the property. So he could have noticed the surveillance cameras or found nothing worth stealing inside the actual construction site and stole something out of one of the boats. Also, this is likely the person that was stealing stuff from the neighborhood over time. The reason I give you that background is because I think it's important that you guys know what was actually going on. This wasn't a case of angry racist white people chasing down a black person for jogging. That did not happen. However, this still adds up to look like felony murder. Now, with that being said, the defense counsel in this case was looking pretty good, pretty slick, pretty charismatic, and I was impressed with the performance. Now, I haven't been keeping up with the trial day to day, but I have been checking out, and I was filled in a little bit by Nate the lawyer, and I'm going to recommend his channel, because when I showed up in his live chat and I was asking him questions about stuff he had already gone over, he literally took the time to explain to me what the major development was in the case that day, and I think that's crucial because he pointed me in the right direction and I don't have to sift through the entire trial, so I'm giving him a recommendation based on that. Now, the thing that came out in the trial was that Arbery was believed by the police to be an armed and dangerous burglary suspect.
That is me. You got your flashlight in one hand and your police-issued firearm in the other?
Yes.
Okay. Guns drawn?
Yes, sir.
Okay. Okay.
The county police, anybody in here?
Let me stop for a second. You got your gun drawn, but it's a burglary or trespassing. It's a property crime. So why is your gun drawn?
I believe at that point then that we were notified, I guess dispatch had notified us that possibly armed.
So it's for your protection.
My protection.
Not to hurt anybody. It's to protect you.
Absolutely.
In case somebody jumps down from the rafters we're looking at.
Yes, sir.
And surprises you.
Yes, sir.
You need to protect yourself.
Yes, sir.
You need to protect Officer Sherman.
Yes, sir.
You need to protect Greg McMichael, Travis McMichael, and Diego Perez, because they're in danger too.
Possibly.
You don't know what's going to happen.
I do not.
But you don't take any chances.
Not at all.
Okay. So it's standard procedure when you go into a possible armed situation to make sure you have your gun ready.
Yes.
For your protection.
Yes, sir.
Okay.
So much so, and I've not really ever heard of this happening before, that when the police were searching the property under suspicion of encountering Arbery, they actually asked the McMichaels to come with their weapons, this is prior to the shooting obviously, and clear the area with them. That's how much of a threat they anticipated for this person.
We don't see him back there unless he jumped the fence this way or
Travis just walked down there. He's going in our backyard to check back this way.
Okay.
He's armed, by the way.
Okay.
Stop right there. So at this point, Greg McMichael is talking to you, correct? And Greg McMichael is telling you that Travis just walked down there. He's going in my backyard to check back this way.
Yep.
So Mr. McMichael, Travis McMichael, at this point is kind of expanding the search.
Going down, I took that as he's going down to his residence.
In the backyard, or I'm sorry, yeah, he's going in my backyard to go check back this way, right?
Yes.
Because it's possible that the black male intruder is left that scene and is in somebody else's backyard.
Possibility.
And Travis is checking that out.
Yes.
And Travis is checking it out on February 11th, 2020 with a gun.
I don't know that he is checking out other people's backyards.
No, his backyard.
He's going to check out his backyard, yes.
And he's armed.
Yes, he is.
Just like he was armed when he was back at Larry English's house.
Yes.
You're okay with that?
Yep.
No problem. He's right to carry a firearm.
He does.
And just like you're needing it for protection, he has the right to protect himself as well.
He does. On his property, yes.
On any property, he has the right to protect himself.
Yes.
Okay.
And this leads us into the defense theory of defense. What they're essentially arguing is that the citizen's arrest law covers two components, and the McMichaels, since they knew from the police that Arbery was a felony burglary suspect that was dangerous, didn't need to meet the first component in order to pursue him. They only needed to meet the second component, which addresses felonies. So let's break down what the statute actually says so you can understand this, and I'll play clips from the defense counsel explaining their theory of defense. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. Period. And that period is very important. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. Now, real quick, I've been getting a lot of comments lately on how I was wrong about the Arbery case and how I was wrong in my reading of the citizen's arrest law, But as it was determined by the judge in his instructions, I was exactly right. The citizen's arrest law grants special protections when pursuing felony offenders, but does not limit you to arresting only people that you see or have immediate knowledge thereof committing felonies. Don't believe me? Hear it from the judge yourself.
I don't read the statute the same way as the defense. I read into the statute. The first line addresses both felonies and misdemeanors. The second sentence narrows that then down to felonies. It doesn't discount misdemeanors. It just says in the case of felonies, if there's an escape going on, then the arrest can be effectuated. The way I read that is if it's a misdemeanor, the guy can be arrested, gal, whoever it is, can be arrested by whoever is effectuating the citizen's arrest. But if they run, then you can't go chasing after misdemeanors. In the case of a felony, you can. And a person who is chasing somebody who's escaping on a felony that is justified upon reasonable and probable grounds for suspicion can effectuate the arrest.
Now, I knew this for 3 key reasons, and I'm going to break them all down for you so that you can understand them. The first one is I'm not an idiot, and I know for a fact that those celebrity race grifter lawyers like Benjamin Crump do not practice in the state of Georgia or most of the states that they're in. So when they give an interpretation of what they believe the law to say, and that gets reported by the media, I'm not dumb enough to just take that as gospel. I actually look into it and read the statute for myself. Number 2, I was well aware, and I was explaining this when we were talking about the video, that citizens' arrest jurisprudence did not start in the year 2010 when this law was passed. Also, in the state of Georgia, most citizens' arrests have to do with misdemeanor shoplifting, so it'd be weird if citizens' arrests only covered felonies when it clearly says, if you look up their numbers, most citizens' arrests are due to misdemeanors. Citizens' arrest doctrine dates all the way back to English common law, so just looking at something from 2010 and saying this is the only thing that factors in, and there's no court decisions or anything like that that outlines the parameters of what a citizen's arrest is ridiculous. And thirdly, the law was passed in 2010. If you know anything about the era, this is not an era of limiting what you can do with your Second Amendment rights in this nation, specifically in the South. This is an era of expansion of rights for gun owners, open carry, concealed carry, constitutional carry. All this stuff started percolating and accelerating during this period of time. So it would be really weird in the state of Georgia to have this outlier piece of legislation that is constraining those rights when everything in their state law and the trend in the nation is to expand those very same rights. So for all you lowlifes, losers, and scumbags that thought you had a one-up on me, congratulations, the judge just ruled in my favor. You're embarrassed. I was 100% right. As always, 100% time is true on this channel. In fact, even when I make a mistake on this channel, both the mistake and my later correction and acknowledgement of that error are in fact correct. That's how ridiculously accurate I am when I talk about things on this channel. But setting that aside, setting the fact that I was right and everybody who disagreed with me was in fact wrong on this issue, there's something very important that you need to understand about the defense's theory of defense when it relates to this, because they concede the first sentence in their defense of the McMichaels. They say that the Michaels were not responding to a crime that they saw, nor a crime that they had immediate knowledge thereof.
We're not contending there was a crime committed in their presence, but there was probable cause to believe a felony had been committed and that this man was attempting to escape or flee.
However, their argument is essentially that when somebody commits a felony, you can still arrest them even if you don't arrest them immediately after they commit the felony, just like the police. If they get away with it and you see them again, you could obviously initiate a stop and initiate an arrest. They're separating out that second sentence and going with the second standard laid out in that second sentence, the reasonable suspicion, and saying that this is what the McMichaels were acting on. Therefore, they were legally allowed to be where they were allowed to be. So when Arbery attacked them, which is undeniable on video, this is a justified act of self-defense, not a felony murder. And they've made this case pretty well throughout the course of the trial. In fact, as I was watching this, even though I believe this was a felony murder based on the video, based on what was reported in terms of the circumstances, I thought that the defense might be able to create enough reasonable doubt to secure an acquittal. However, this totally became undone once the judge decided that he was going to go with the jury instructions that he was going to go with.
So the charge that I am going to provide, I'm going to amend a little bit from the state's language, and that is that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of a felony, during the escape. If the observer fails to make an arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. I'm not going to comment on the legality or illegality, so I'm putting a period at the end of extinguished, and removing the "and a subsequent arrest" is illegal. So again, private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during escape.
I'm sorry, could you say that last portion again?
Or in the case of a felony, during escape. If the offender fails to make the arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. That's what the court intends to charge. I understand there's an exception from the defendants.
Judge, if you charge the jury the way you're contemplating, you are directing a verdict for the state. You are rendering the second sentence in which it describes reasonable and probable grounds of suspicion meaningless. It's in there presumably for a purpose. It's a different burden than immediate knowledge or presence. And so I would urge the court to reconsider and eliminate this, let the state argue what they're going to argue. We have built this whole case around the probable cause, second sentence, last phrase that Travis McMichael and Greg McMichael had on February 23rd for events that happened previously. And you are gutting all of it if you give this particular charge.
Now, essentially what the judge just said right there is that what the defense was arguing throughout the entire trial, because remember, this is during the instructions phase for the jury, is not valid, and he's going to direct the jury that that defense is not valid, which means he's essentially commanding a guilty verdict. Now, this isn't set in stone at this point. He did ask for the defense to send their citations and their argumentations for why he should change the directions, but if this stands, the McMichaels are going to be convicted because the judge is essentially telling them to convict this guy and his father.
May I ask, Your Honor, if, I know we're Friday at 2:30, if over the weekend we were able to email to you or your staff a full, complete with citations argument for what position we're arguing for here, that this contemporaneity of the offense for which you are fleeing and being chased.
Now, I don't presume to be an expert in Georgia law. I don't presume to be an expert in the way that the state of Georgia conducts trials. But to me, this is absolutely devastating to drop on the defense during the phase where you're outlining your instructions for the jury.
Why don't we do this? This is what I intend to charge. I'm not going to reopen all of the charges. I understand the significance of the charge that is presented. I will, if I'm provided something, at least on a timely basis over the weekend, where I can digest and the state then have an opportunity to digest and respond. This charge, I will remain, the intent is as I've described. But if I'm provided different authority than I've already been provided, I will go ahead and reconsider upon the presentation of any additional authority that may come.
I mean, to give you an analogy on exactly how bad this would be for the defense's case, the defense who has presented themselves really well and really charismatic throughout, it would essentially be like you getting your good best suit, $2,000 suit, fits snug, you look tight, you got that swag, you go into a casino, you spot the cards table, you walk over there with all your confidence, you pull up a chair backwards, you sit in it, arms on the table, total authority in everything that you're doing. You look at the person and you say, deal me in. And the person looks right back at you and says, I'm playing solitaire. Yes, it really is that bad for the defense if these instructions are unchanged given to the jury. Now, I thought the state had a good case and they would likely be able to secure a felony murder conviction against the McMichaels, but honestly, you're basically handing it to them. And I wonder if you end up structuring the instructions in this manner, if you can argue on appeal that you have ineffective counsel, because if your defense's line of defense, the theory of defense that they're going with, essentially is you saying, I'm guilty over the course of a week and a half, that's the most ineffective counsel ever. And I think the attorney did a good job. I think on cross-examination, the attorney did a lot of good work. But if he just conceded the case without even realizing it, I think by definition, that is ineffective counsel. So we might see an appeal and this be started up all over again, in which the prosecution would have the same good chance of getting a conviction that I thought they had going into this. But the defense, if they laid it out this way and the judge rules that this is how the jury has to interpret the law, essentially gave a conviction without actually doing a plea deal. So they didn't get anything for it, which is a disaster for both the McMichaels. And I would be looking at my attorney like, dude, you did all that song and dance, all that show. It was so impressive. And you just said we did it. You screwed us over, which honestly would be true. But hey, look, those are just my thoughts. Let me know your thoughts down in the comments below. As I said earlier in the video, Nate the Lawyer's channel will be linked in the description. If you want to learn more, he's been covering this wire to wire. I don't know how he has so much time to stream 2 trials concurrently. Insane. So definitely check him out and thank him for his good work. I probably would not have been able to make this video for another week if not for watching some of his content and being directed where I need to be directed to. Like the video, show me by leaving a like, you subscribe for more content, follow me on my social media, support me via the support links down in the description box, get the merch while it's available. Till next time.